أعوذ بالله من الشيطان الرجيم.
يا أيها الذين آمنوا كونوا قوامين بالقسط شهداء لله ولو على أنفسكم أو الوالدين والأقربين إن يكن غنيا أو فقيرا فالله أولى بهما فلا تتبعوا الهوى أن تعدلوا وإن تلوا أو تعرضوا فإن الله كان بما تعملون خبيرا.
بين العلاقات الإنسانية بمختلف أشكالها والشراكات التجارية على تنوعها، وما بين الأنظمة التي تنظم تفاصيل حياتنا الصغيرة والدساتير التي تصون كيان الدول وتوجه مسيرتها. نجد القانون حاضراً يرسم الطريق ويعيد الميزان حين يختل، حاضراً في تفاصيلنا الصغيرة قبل قضايا العالم الكبرى، وهو الذي يجمعنا على الرغم من اختلافنا. الحمد لله الذي أقام العدل ميزانا وجعل الحق سلطانا وأودع القوانين في حياة الناس أمانة. والصلاة والسلام على من بعثه الله رحمة وعدلا وهدى وفصلا، نبينا محمد وعلى آله وصحبه أجمعين. أصحاب المعالي، أصحاب الفضيلة، أصحاب السعادة، أيها الحضور البهي، السلام عليكم ورحمة الله وبركاته. القانون ليس نصاً جامداً ولا حبراً على ورق، بل صمام أماننا في زمن التحولات والبوصلة التي تعيدنا إلى المسار الصحيح. وفي اليوم العالمي للقانون نلتقي جميعاً لنحتفي بهذه الرسالة العظيمة، ولنؤكد أن القانون ليس مهنة فحسب، بل هو رسالة حياة ومشروع أمل دائم لكل من يطلب العدل والإنصاف. معكم عالية الباتلي، طالبة قانون بجامعة الأمير سلطان، ويسعدني ويشرفني أن أرحب بكم جميعاً في ملتقى وزارة الخارجية الأول لليوم العالمي للقانون، بالشراكة مع المركز السعودي للتحكيم التجاري، والذي فيه نحتفي بالقانون رسالة وحياة. يعجز لساني عن وصف سروري وعظيم امتناني لوجود مثل هذه الفرص التي طالما كانت محطة فارقة صقلت مهاراتي ومهارات زملائي وزميلاتي المهتمين بالقانون، ما من شأنه تجسيد استثمار وطننا الغالي في صناعة جيل جديد يؤمن بالعدالة ويحمل رسالة القانون إلى المستقبل. والآن يسرني دعوة سعادة الأستاذ محمد بن سعود الناصر، المدير العام للإدارة العامة للشؤون القانونية بوزارة الخارجية، لافتتاح الملتقى وإلقاء كلمته مشكوراً.
عز وجل هذا الكون من العدم خلقه بنظام بديع وقوانين كونية ثابتة. لا يزال العلماء حتى عصرنا هذا يقفون منبهرين أمام هذه القوانين الدقيقة التي جعلها الله سبباً في استمرار الحياة على هذا الكوكب، وضماناً لتمكين الإنسان من العيش وتوفير احتياجاته من الهواء والماء والغذاء، وبناء العلاقات وتبادل الخبرات والتعلم والتعليم. ومن هنا تبين للإنسان ومنذ العصور الأولى أنه ملزم باحترام القوانين الكونية من جهة، وملزم بوضع قوانين وأنظمة تمكنه من استمراره الوجودي على هذا الكوكب. ونحن اليوم نجتمع تحت راية القانون والعدالة لنحتفي باليوم العالمي للقانون، الذي تحتفي به وزارة الخارجية ممثلة بالإدارة العامة للشؤون القانونية، إيماناً منها بأن القانون ليس مجرد نصوص جامدة، بل هو لغة الحياة والسلام بين الأمم، وجسر الثقة بين الشعوب، ودرع يحمي الحقوق والمصالح، ويضمن استمرار الحياة والتطور والحضارة الإنسانية. وبالنسبة لوزارة الخارجية، يشكل القانون البوصلة التي توجه دبلوماسيتها، والميزان الذي تزن به مواقفها، والميثاق الذي يربطها بالتزاماتها الدولية، بما يعكس مبادئ المملكة الراسخة وقيمها العادلة. إن إحياء هذه المناسبة العالمية يأتي تأكيداً على إيمان المملكة العربية السعودية العميق بأهمية سيادة القانون كركيزة أساسية في بناء المجتمعات العادلة، وضمان الحقوق وصون الكرامة الإنسانية، كما يجسد التزام وزارة الخارجية بمواصلة دعم الجهود الوطنية والدولية في تطوير القوانين والتأكيد على الالتزام بها، وتبادل الخبرات وتعزيز التعاون المؤسسي في هذا المجال. نجتمع اليوم لنؤكد أن قوة النص القانوني وحكمة التشريع والقدرة على استطلاع المستقبل ومواكبة التحديات والتطور التكنولوجي هي الركيزة التي تبنى عليها جسور التعاون الدولي، ويصان بها أمن الشعوب وكرامتها، وتحفظ بها الحقوق والمكتسبات والتقدم بكل مجالاته. وذلك يتطلب تطوير وتحديث الأنظمة السارية وإصدار أنظمة ولوائح جديدة، وهو ما يحظى باهتمام بالغ من لدن حكومة مولاي خادم الحرمين الشريفين الملك سلمان بن عبد العزيز وسمو ولي العهد الأمين حفظهم الله. ويدل على ذلك الحراك القانوني الكبير الذي تشهده المملكة وفق رؤية المملكة 2030. في هذا الإطار نتطلع أن تسهم هذه الفعالية بما تحمله من حوارات قانونية ونقاشات متخصصة في إثراء الفكر القانوني وتوسيع آفاق المعرفة وتوثيق جسور التواصل بين الخبراء والمختصين وطلاب القانون. فأهلا بكم في هذا اللقاء، وشكرا لحضوركم الذي يضيف لهذا الحدث العالمي قيمة ومعنى.
شكرا لكم سعادة الأستاذ محمد على كلماتكم الثرية. والآن يسعدني دعوة سعادة الدكتور حامد بن حسن ميرة، الرئيس التنفيذي للمركز السعودي للتحكيم التجاري، لإلقاء كلمة الشريك الاستراتيجي.
الحمد لله، وصلاة وسلاما على رسول الله. أصحاب السمو والمعالي والفضيلة والسعادة، السيدات والسادة، السلام عليكم ورحمة الله وبركاته. 13 من سبتمبر محفل مهيب يجمع أساطين الفقه والقانون بالقادة، ورموز الدبلوماسية والقضاء بالساسة. درة التاج فيه كلمات مولاي الملك، إذ يقول: إن المملكة العربية السعودية قد آمنت دائما بأهمية سيادة القانون في العلاقات الدولية، وقد دعمت باستمرار جميع الجهود الرامية إلى تعزيز أسس العدالة والإنصاف بين الأمم، إلى أن قال: نحن ننفذ الحكم الذي أصدرته محكمة تحكيم لصالح شركة أجنبية ضد الحكومة بنفس الصرامة والسرعة التي ننفذ بها حكما صادرا لصالحنا، ونحن نقوم بذلك طواعية وبإرادتنا، لأننا ننفذ أحد أوامر الله تعالى بذلك. كلمات أرست سيادة القانون ورسمت قانون السيادة ببلاغة الفعل لا بفصاحة فقط فصاحة القول يا سادة. كلمات أرست سيادة القانون ورسمت قانون السيادة ببلاغة الفعل قبل فصاحة القول يا سادة. كان ذلك في رسالة الملك فيصل بن عبد العزيز رحمه الله، التي قرأت في مثل هذا اليوم قبل 60 عاما في مؤتمر السلام العالمي من خلال القانون، الذي عقد في واشنطن عام 65 و900 وألف، والذي كان فيه إطلاق النسخة الأولى من الاحتفائية السنوية باليوم العالمي للقانون. نعم، فحماية حياد التحكيم وجنابه وتعزيز كفاءة تنفيذ أحكامه كان هو المثل الذي توج به مولاي الملك للقانون سيادته. أتى هذا التصريح بعد إصدار هيئة التحكيم لحكمها ضد حكومة المملكة ولصالح شركة الزيت العربية الأمريكية في قضية تحكيم شهيرة في نهاية الخمسينات من القرن الماضي، عرفت بقضية أونسس، والتي فيها من التفاصيل والعبر ما يضيق مقامنا بذكره. ولكن من أبرز ما يمكن تسليط الضوء عليه أن هيئة التحكيم الأجنبية فيها نصت على تجاهل أنظمة المملكة وقوانينها رغم اتفاق الطرفين عليها. أصبح ذلك تاريخاً لن نقف على أطلاله، بل نستلهم من عبره وآثاره. إن وجود صناعة تحكيم متطورة وتحقيق منظومة تسوية منازعات فاعلة ممكن رئيس للأعمال ومعزز للثقة في البيئة التشريعية والأمان القانوني بها، ومخفض لمخاطر الاستثمار ورافع لجاذبية بيئته. أيها الحفل الكريم، علمنا التاريخ قبل الحاضر أنه لا يمكن تطوير منظومة تسوية منازعات في وطن من خلال استيراد مركز تحكيم من المغرب أو المشرق، فما حك جلدك مثل ظفرك وما حملك مثل ولدك. لا يمكن أن تتحقق في هذا المجال نهضة ما لم تكن هناك رؤية تسندها عزيمة وجهود متضافرة في بناء كامل المنظومة يتناغم فيها التطوير التشريعي مع الدعم القضائي والتكامل الحكومي وتطوير الكوادر البشرية وتطبيق أفضل الممارسات الدولية. يصحب ذلك استفادة من الآخر حيث كان لا الارتهان له، والاستلهاب من ناجح التجارب لا الوقوع في أسرها، وتقديم ذلك بأسلوبك وطريقتك في استقلال واعتزاز بهويتك وإرثك لتكون إضافة للدنيا لا مجرد نسخة من غيرك. هذا بالفعل ما أثبتته التجارب الناجحة عالمياً التي جمعت ما سبق وضمت له تمكين مركز تحكيمها الوطني، بل وصدرته للعالم، ولم يفتح مركز تحكيم أجنبي في تلك الدول إلا بعد ربع قرن من بناء كامل المنظومة وجهوزيتها. مضت أونسز وقضيتها ودار الزمان دورته ليحتضن هذا الوطن اليوم منظومة تسوية منازعات متكاملة في القلب منها مركز تحكيم مستقل، المركز السعودي للتحكيم التجاري، الذي أصبح محل ثقة قطاعات الأعمال والمستثمرين حول العالم، ومن أسرع مراكز التحكيم نمواً في سجل قضاياه نوعاً وعدداً، بل انتمت إلى 30 دولة جنسيات أطراف المنازعات التي وضعت ثقتها فيه وأحالت قضاياها إليه، وأصبح يلجأ إليه في منازعات كلا طرفيها من خارج المملكة. تغير الكثير في 70 عاماً، ولكن بقي أمر ثابت لم ولن يتغير، بل تزيده السنوات رسوخاً: احترام هذه المملكة العظمى لسيادة القانون، والالتزام بحياد التحكيم واستقلاله وإنفاذ أحكامه، سواء أكانت صادرة علينا أم لنا. لا غرو، فسيادة القانون وإقامة العدل وحفظ الحقوق وأداؤها لأهلها عقيدة ودين نتعبد الله به، تلقيناه من شريعتنا الغراء التي تأسست هذه البلاد المباركة عليها، وقررها ملوكها وقادتها بالفعل قبل القول، ابتداء من الملك المؤسس طيب الله ثراه وأبناؤه الملوك البررة، إلى مولاي خادم الحرمين الشريفين الملك سلمان بن عبد العزيز حفظه الله، وسمو سيدي ولي العهد الأمين الذي يقول: نحن في المملكة نعمل مع الحلفاء ونؤمن بمبدأ سيادة القانون. أيها المحفل الكريم، الشكر والتقدير لكم كل باسمه ورسمه وشريف لقبه على إكرامنا بحضوركم اليوم. كل الشكر والامتنان لمقام وزارة الخارجية، وعلى رأسها صاحب السمو الأمير فيصل بن فرحان آل سعود وزير الخارجية، وأصحاب المعالي والسعادة قياداتها الموقرة، وشركاء النجاح في الإدارة العامة للشؤون القانونية فيها، وجميع المتحدثين والخبراء والرعاة واللجنة المنظمة المتميزة. الشكر لكم مجددا، ونتطلع للقاء بكم في مثل هذا اليوم من العام القادم بإذن الله. وإلى ذلك الحين ليبقى حاضرا في الأذهان أن استقلال التحكيم ما زال وكان للحق والعدل وسيادة القانون سفيرا فوق العادة. أيها السادات والسادة، والسلام عليكم ورحمة الله وبركاته.
شكرا لكم سعادة الدكتور حامد على كلمتكم الثرية. والآن ندعوكم لمشاهدة العرض المرئي والذي يسلط الضوء حول الإدارة العامة للشؤون القانونية في وزارة الخارجية، إذ نستعرض معا أهدافها ومهامها وأبرز إنجازاتها.
القانون هو الأساس الذي تستند إليه العدالة وتستقر عليه الدول، هو ركيزة للاستقرار وأداة لحماية الحقوق. في الإدارة العامة للشؤون القانونية بوزارة الخارجية نجسد هذه المبادئ ضمن رؤية وطنية شاملة، مستنيرين بتوجيهات القيادة الرشيدة حفظها الله، ومتسلحين بقيم النظام الأساسي للحكم التي تؤكد على العدل والمساواة واحترام الاتفاقيات الدولية. نعمل ضمن منظومة دبلوماسية تسعى لتحقيق المصالح الوطنية والمساهمة في بناء بيئة دولية أكثر أمناً وازدهاراً، مدعومين بكفاءات قانونية متخصصة ونظم تقنية متقدمة. وفي هذا اليوم نطلق شعارنا لهذا العام: معاً لعدالة دولية وشراكة قانونية فاعلة، تأكيداً لالتزامنا بمواصلة تطوير أدواتنا القانونية وتعزيز دور القانون في العمل الدبلوماسي السعودي.
في وزارة الخارجية للقانون دور جلي وحاضر في كل تفصيل، من مراجعة للأنظمة والتعليمات إلى ضبط للإجراءات والتصرفات وفق الأطر النظامية. نعمل في إدارتنا على تقديم الاستشارات القانونية لكافة قطاعات المنظومة، كما نعمل على تسوية المنازعات وتمثيل الوزارة في القضايا الداخلية، مما يعزز بيئة العمل ويضمن الشفافية والامتثال. القانون هو التزام تشاركي يبدأ من أصغر قرار إداري إلى أعلى توجيه مؤسسي.
في عالم تتداخل فيه القوانين وتتعاظم التحديات العابرة للحلول، يمثل القانون الدولي أداة توازن ومسؤولية مشتركة، وعليه نقدم في إدارتنا الدعم القانوني المتخصص في الملفات الدولية، من اتفاقيات السادة والاختصاص إلى مفاوضات المعاهدات مرورا بالقانون الدولي الإنساني. ونتابع عن كثب أعمال المنظمات والمحاكم الدولية، لأننا نؤمن أن القانون ليس نصوصا جامدة، بل هو وسيلة لحماية الإنسان وتنظيم العلاقات بين الدول. التزام الدول بالقانون هو التزام بمستقبل أكثر عدلا واستقرارا لنا جميعا.
في ضوء التطورات المتسارعة للعقوبات الاقتصادية أحادية الجانب وما تحمله من آثار مباشرة وغير مباشرة على استقرار دول المنطقة والعالم، تقوم إدارة العقوبات الأحادية بدور رصدي واستباقي واستشاري، نرصد التداعيات المحتملة والمخاطر القانونية لتلك العقوبات ضمن إطار القوانين والتشريعات ذات الصلة، وبنهج متكامل نعمل على تعزيز دور المملكة في ترسيخ الأمن والاستقرار ودعم مسارات الازدهار إقليميا ودوليا.
والآن يسرني دعوة معالي المهندس وليد بن عبد الكريم الخريجي نائب وزير الخارجية لتشريفنا بإلقاء كلمة ضيف الشرف وتكرم معاليه بالبقاء على المنصة لتكريم رعاة الملتقى.
بسم الله الرحمن الرحيم. أصحاب المعالي والفضيلة والسعادة، السيدات والسادة الحضور الكرام، السلام عليكم ورحمة الله وبركاته. يسعدني أن أكون بينكم اليوم في هذا اللقاء المتميز الذي تنظمه وزارة الخارجية ممثلة بالإدارة العامة للشؤون القانونية، احتفاء باليوم العالمي للقانون الذي يجسد في جوهره قيمة سامية وركيزة أساسية من ركائز استقرار الدول وضمان حقوق الأفراد والمجتمعات. إن القانون ليس مجرد نصوص مكتوبة أو لوائح منظمة، بل هو منظومة متكاملة من القيم والمبادئ التي تضمن العدالة والمساواة وتحفظ الحقوق وتبني جسور الثقة بين الدولة ومواطنيها وبين الدول وبعضها البعض. وفي عالمنا المعاصر الذي تزداد فيه التحديات وتتقاطع فيه المصالح، يبرز دور القانون الدولي والدبلوماسية القانونية كأداة حضارية لتسوية النزاعات وتعزيز التعاون وتحقيق التنمية المستدامة. لا يخفى على أحد أن وزارة الخارجية من خلال إدارتها العامة للشؤون القانونية تؤدي دورا محوريا في تمثيل المملكة قانونيا على الساحة الدولية وصون مصالحها والتأكد على التزامها بالمعايير القانونية والاتفاقيات الدولية، بما يعكس شورى مشرفة لوطننا الغالي ويعزز من مكانته بين الأمم. في هذا اليوم ونحن نحتفي بالقانون، فإننا نحتفي في الحقيقة بروح العدالة وبجهود القانونيين وأعضاء السلك الدبلوماسي وجميع الشركاء في مسيرة التطوير. والحراك القانوني الذي تشهده المملكة يمثل أحد أهم ركائز وأهداف الرؤية المباركة 2030. وفي هذا المجال الذي حظي ولا يزال يحظى باهتمام بالغ من لدى حكومة سيدي خادم الحرمين الشريفين الملك سلمان وسمو سيدي ولي العهد الأمين حفظهم الله. مرة أخرى أرحب بكم جميعا، ونحتفي إن شاء الله بهذه المناسبة أعواما مديدة، والسلام عليكم ورحمة الله وبركاته.
نشكر معاليكم على كلماتكم الثرية. والآن أود أن أدعو سعادة الدكتور وليد بن سليمان أبانمي رئيس مجلس إدارة المركز السعودي للتحكيم التجاري باعتلاء المنصة ومشاركة معالي نائب وزير الخارجية لتكريم شركاء نجاح الملتقى، والذي كان لعطائهم ودعمهم أثر بالغ في انعقاد هذا اليوم، فشكراً لهم وشكراً لكل يد أسهمت في أن يرى هذا الملتقى النور. والآن نستهل بتكريم الراعي الأول شركة تثبت، ممثلة بسعادة المهندس علي بن ناصر العسيري الرئيس التنفيذي. كما ندعو الراعي الثاني المركز العربي للقانون، ممثلاً بسعادة الدكتور نايف بن هادي اليامي نائب الرئيس التنفيذي. والآن نود أن ندعو الراعي الثالث شركة الدكتور أحمد الصقيه ومشاركوه محامون ومستشارون، ممثلاً بسعادة الأستاذ عبد الرحمن السلطان. والآن نود أن ندعو الراعي الرابع منصة قانونية، ممثلة بسعادة الأستاذ يحيى بن أحمد العمري الشريك المؤسس. نود أن ندعو الراعي الخامس المركز السعودي للحوكمة ممثلاً بسعادة الأستاذ ناصر بن سعود السهلي رئيس مجلس الإدارة. كما ندعو الراعي السادس شركة حامد سعود العتيبي للمقاولات ممثلاً بسعادة الأستاذ سلمان بن حامد العتيبي. وختاماً يسرنا دعوة الشريك المهني للملتقى الهيئة السعودية للمحامين ممثلة بسعادة الأستاذ عبد العزيز بن علي الجفير مساعد الأمين العام. شكراً لشركائنا الكرام على دعمهم. والآن ننتقل إلى الجلسة الحوارية الأولى، حيث تتناول هذه الجلسة موضوعاً محورياً بعنوان الحصانة، المبدأ وتطوره، والتي ستعقد باللغة الإنجليزية، إذ نود أن ننوه إلى أن أجهزة الترجمة الفورية إلى اللغة العربية متاحة. Ladies and gentlemen, distinguished guests, we now move on to our first session entitled Immunity, the Principle and its Evolution, where it is our pleasure to introduce our panel speakers. والآن يسعدنا أن نستضيف نخبة من المتحدثين الخبراء، إذ ندعوهم بالتفضل إلى المسرح. سعادة الأستاذ جيسون رايت الشريك في ستبتو للمحاماة. سعادة الأستاذ جورج كهالي الشريك ورئيس مجلس الإدارة في كورتس مالت بريفوست كولت وموصل. سعادة الأستاذ جوناثان إبراهيم مارشال الرئيس التنفيذي لمكتب الشؤون القانونية الدولية. وسعادة الأستاذ ماركوس بيرغستولر الشريك في هوغن لوفلز للمحاماة. وسيدير الحوار سعادة المستشار عبد الرحمن شيخ مدير إدارة القانون والدعم الدولي بوزارة الخارجية.
Thank you so much. Your Excellencies, distinguished guests, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. It is indeed a great honor for me to moderate the first panel of the first ever Law Day Forum organized by the Ministry of Foreign Affairs and the Saudi Center of Commercial Arbitration. Our opening session addresses a subject that lies at the very core of international law and diplomatic practice: immunity, the principle and its evolvement. Immunity is a cornerstone of relation among states, providing the framework for diplomats, state officials, and institutions to perform their duties and function with confidence and protection required. Yet, like all principles of law, immunity is not static. It evolves, and it evolves to the changing dynamics of international relations, judicial practice, as we will see today, and global expectations and demands. Significantly, political and geopolitical recent developments would have an impact on shaping the recent understanding of the principle of immunity. In this session, we are privileged to hear from distinguished experts who will be discussing the origin of the principle, trace its development, and explore the current debates shaping its application today. Their perspectives will help us for better understanding and to see what is coming in the future regarding this principle. I invite you all to join me in welcoming our esteemed panelists as we begin this very important conversation. I will just start introducing the member maybe with a few words, starting with my immediate left, George Kahili, Curtis Chairman, the well-known law firm, and one of the world's leading international lawyers with very extensive experience in international law and particularly in state immunity. He wrote several articles in civil immunity, and with more than 50 years of experience in international law, we are privileged to say that George is the first lawyer to call when MOFA has a public international law question. Next to him, Dr. Marcus Bergstaller is a partner at Hogan Law Firms in London and has extensive experience in public international law at the highest level of government, with many years of experience in private practice. He advises clients on all questions of public international law, including the questions of state immunity, which is the subject of our session today, and acts for state international organizations and individual international disputes. He is nominated to the ICSID panel arbitrators by the Austrian government. Next to Dr. Marcus is Jason Wright, is an American trial and national security lawyer, international law professor, and Bronze Star decorated combat veteran. He regularly advises sovereign entities and government officials on economic sanctions, regulatory compliance, international law, and cross-border transactions. Jason holds advanced international law degree from University of Oxford and has taught international law at Georgetown University Law School, Washington and Lee University School of Law, and the U.S. Military Academy at West Point. Jason is a partner of Steptoe LLP in New York, and also Jason provided significant support actually to MOVA in the last 3 years before in his previous role. At the far left of me is Jonathan Ibrahim Marshall, who recently appointed as the CEO of the Kingdom's International Legal Affairs Office, with the mandate to oversee international legal cases to which the Kingdom of Saudi Arabia is a party. Jonathan has been defined by extensive work at the intersection of international law, finance, and public policy, and prior to his role in the government, worked in private practice for several global law firms. In recognition of his contribution to Saudi Arabia's legal sector and his role in developing Saudi legal talent, Jonathan was granted Saudi citizenship in 2024 by the custodian of the two holy mosques, King Salman bin Abdul Aziz. We'll start our session, and allow me to begin with Jason Wright. Given your, Jason, expertise as being a professor actually in international law, to what extent does the internationally accepted definition of state immunity reflects truly universal principle? You have almost 10 minutes, and I would remind you if we go out of the time.
Thank you.
Yeah.
Let me try a little bit louder. All right. Thank you, Abdul Rahman. I will try not to take the full 10 minutes, but appreciate the question. So good morning, Your Excellency, distinguished panelists, esteemed guests, and colleagues. It is an honor to participate here today in this important discussion on immunity and its evolutionary role in promoting the rule of law through commercial dispute resolution. My brief opening remarks today will focus on the concept of state immunity, its definition, its fundamentals, and to the extent that there might be an international consensus. State immunity is a cornerstone of international law, one grounded in the recognition of sovereign equality of nations, a principle enshrined in the United Nations Charter and deeply rooted in history. As we delve into its fundamentals, we must recognize its pivotal role in balancing state sovereignty with the growing complexities of global interconnectivity to include trade, commerce, and investment. Let me now turn to the definition and the fundamentals of state immunity. State immunity, at its core, refers to the legal doctrine under which a sovereign state is exempt from being sued in the courts of another state without its consent. It protects a state and its property from the jurisdiction of the courts of another state. This principle emanates from a Latin concept of par in parum non habet imperium, meaning an equal has no dominion over an equal. By protecting states from legal exposure in foreign domestic courts, immunity reinforces the independence and dignity of sovereign entities and ensures the proper functioning of the international system. Traditionally, there have been two types of state immunity. The first is absolute immunity. This is a historical approach which provided states complete protection from judicial proceedings, regardless of the nature of their actions. In essence, a state could not be sued for any activity it engaged in, whether sovereign or commercial in nature. The other is called restrictive immunity. Over time, as international trade expanded and states began engaging in activities similar to those engaged in by private entities, a shift occurred toward restrictive immunity. Under this modern framework, immunity applies to sovereign or public acts, in Latin called jure imperii, but not to commercial or private acts, in Latin called jure gestionis. Restrictive immunity strikes a balance between respecting state sovereignty and allowing private parties to seek justice in commercial disputes. This evolution has paved the way for arbitration and international dispute resolution mechanisms to become key tools for handling matters where immunity is limited. The United Nations Convention on Jurisdictional Immunities of States and Their Property is the most comprehensive codification of these principles. It affirms state immunity while providing exceptions, particularly for commercial transactions. Although it has not yet been universally ratified, the Convention reflects a widely accepted consensus on the fundamentals of immunity. The question arises, however, does the internationally accepted definition of state immunity reflect a truly universal principle? From a legal standpoint, the fundamentals of immunity have broad acceptance, codified in treaties and upheld by domestic courts, and also supported by customary international law. Yet in practice, the application and interpretation of state immunity can vary, revealing disparities and challenges in its universality. Mr. Abdul-Rahman, thank you for letting me present these brief opening remarks.
Thank you, Jason, for your valuable points thank you so much, Jason. Building on that foundation, I would like to turn to Jonathan and I would ask, in your view, how is the concept of state immunity evolving in response to today's shifting political and economic and security realities?
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh, Your Excellencies, ladies and gentlemen. I'm particularly honored to be here today as my first engagement as the new CEO of the International Legal Affairs Office. So thank you and the organizers for inviting me. I think, first of all, we need to put it in context of the changing geopolitical and economic context in which we are operating. We are uniquely here today, perhaps for the first time in 2 generations, where there is a major armed confrontation in Europe, where we have an ongoing regional conflict, where international law norms are openly ignored, where we have rising tensions among major Asian powers. And all this has led to an erosion of multilateralism as the consensus in global institutions has become harder to achieve. On top of all of this, we have compounding factors, economic and financial stresses, including sovereign debt risk, weaponized trade and global energy transition, resource competition, rapid technical disruption, especially in cyber operations and the fields of artificial intelligence. And in many countries, we have a human rights polarization, where we have a human rights discourse that is in itself polarizing, where activists are pushing courts to stretch legal boundaries, and where a resurgence of rights portrays these same norms as eroding sovereignty and enabling mass migration. So what does this mean for state immunity? Even the modern doctrine that we just heard of restrictive state immunity is under strain. In many jurisdictions, this line is no longer decisive, as courts and legislators are creating new exceptions driven by politics, human rights, or security concerns. And to give you some examples, central bank assets, traditionally universally regarded as immune from attachment. For the first time, we have states debating whether it is permissible as a matter of international law to seize central bank assets. This is something that even during the First and Second World War, we didn't see. At the moment, there's been a step away from this, where the consensus remains that such reserves are not touched, and instead there's a trend to look at the proceeds of those assets, the interest on those assets. But nevertheless, for the first time, we are seeing this openly debated. We have human rights litigation, where courts have been influenced by rights-based advocacy and therefore asserting jurisdiction over harms which have alleged to be occurred, where harm has alleged to occur in their territory, even where the underlying acts, even if they occurred at all, almost certainly occurred elsewhere. We have many examples, particularly in Europe, the Italian Constitutional Court, but also in Asia, in South Korea and other countries. And thirdly, of course, as many of you are aware, we have statutory-driven precedent and carve-outs where legislatures have enacted exceptions and courts have allowed claims to proceed, even where conduct or consequences are deemed in their perspective to violate universal norms. Finally, just to address very quickly why this matters for states, all states. Strategic exposure. States can no longer rely on a stable, uniform shield when they trade, hold, and invest reserves abroad. Central bank reserves, sovereign wealth funds, and state-owned enterprises may be drawn into foreign courts or enforcement actions. This erosion everywhere weakens protection for everyone else. If one state carves out an exception to reach its adversary's assets or conduct, this clearly invites reciprocal measures against its own assets. Courts are now being used to signal values, punish behavior, which means litigation risk has become an element of foreign policy and economic strategy, not merely a legal technicality. This change in doctrine of sovereign immunity is, in my view, a direct challenge to the sovereign equality of nations that the previous speaker just mentioned. Protecting assets, drafting contracts, and conducting diplomacy now requires an active and forward-looking risk management. This is obviously great for lawyers, but maybe less great for everybody else. And the final takeaway I would just mention, where immunity fragments, sovereignty itself becomes a negotiable aspect, and every state, large or small, needs to plan as if tomorrow's courtroom could be another front line. And these are my thoughts on that, and thank you very much again for speaking.
Thank you so much, Jonathan. Thank you so much. Actually, that leads us naturally to a critical question that I will address to Dr. Marcus. I think Jonathan paved the way for the discussion and see maybe some examples of similar, different understanding that was actually not debatable, as Jonathan said before. So could you share your perspective, please, on whether the current state practice and immunity indicate a shift in interpretation of customary rules, or simply a change in the principle, with some examples?
Thank you very much for the invitation. It's a pleasure to be here. I will focus on 3 issues. The first one is enforcement of investment arbitration awards. The second is a recent adoption in China of a new foreign state immunity law. And the third is the enforcement against assets held by the Central Bank of Russia. The first example that I would try to elaborate on is the enforcement of investment arbitration awards, which has been particularly plentiful in recent times. In particular, there have been a number of cases in relation to the enforcement of what is called intra-EU investment arbitration awards, which are cases by an investor of an EU member state against another EU member state. In particular, there have been a number of cases against Spain, and Spain tried to resist enforcement of these awards on state immunity grounds, which resulted in a number of decisions in Australia, the US, and the UK in particular. Starting with Australia, just a few weeks ago, the Federal Court of Australia enforced 4 Energy Charter Treaty awards against Spain, finding that Spain waived its state immunity by ratifying the ICSID Convention. So Spain's primary case on state immunity was that it had not submitted to the jurisdiction of the Australian courts for the purposes of the enforcement of these investment arbitration awards. But the Federal Court of Australia dismissed Spain's arguments. The court ruled that Spain's acceptance of the ICSID Convention amounted to a waiver of state immunity. The court said that a waiver of state immunity requires, quote, a high level of clarity and necessity. It must be unmistakable, unquote. The English Court of Appeal reached a similar outcome in dismissing an appeal brought by Spain. In a decision in October 2024, the court found that the ICSID Convention amounted to a waiver of state immunity from jurisdiction and a submission to the jurisdiction of the English courts. The court referred to the UK Supreme Court's finding that the UK State Immunity Act is, quote, a complete code, unquote. If the case at stake does not fall within one of the exceptions to immunity stated therein, the state is immune. The US Court of Appeal for the District of Columbia similarly found in August 2024 that the intra-EU nature of a dispute under the Energy Charter Treaty could not be invoked to thwart the arbitration exception of the US Foreign Sovereign Immunities Act. Spain then asked the US Supreme Court to review the Court of Appeal's decision, and it remains to be seen whether the US Supreme Court will agree to hear the case later this month. State immunity questions also came up in relation to the enforcement of the UCOS awards, now worth approximately $63 billion US. For over a decade, Russia has resisted the enforcement of these awards, contending that it never agreed to arbitration under the Energy Charter Treaty. The Dutch courts at the seat of the arbitration rejected this argument. The London Court of Appeal and the Singapore International Commercial Court both dismissed Russia's state immunity defense on the grounds of issue estoppel, concluding that the question of Russia's consent to arbitrate under the Energy Charter Treaty had been determined by the Dutch courts. In a February 2025 judgment, the London Court rejected this argument. And in June 2025, the UK Supreme Court refused to hear Russia's appeal. The second issue I wanted to touch upon is China's recent shift to the doctrine of restrictive immunity. On 1 January 2024, the Foreign State Immunity Law entered into force, introducing statutory exceptions to foreign states' immunity, similar to those in the US and the UK. For example, the new commercial activities exception removes jurisdictional immunity in courts for disputes arising from commercial activities under certain conditions. Additionally, foreign states will not enjoy immunity from execution against a property within the territory of China, where enforcement is for the purpose of enforcing a China court judgment. While I'm not aware of any precedent in which these provisions have been invoked in arbitration-related proceedings, the adoption of the Foreign State Immunity Law is a significant development. The third and final issue I wanted to touch upon concerns the enforcement against Russian central bank assets. Following Russia's full-scale invasion of Ukraine in February 2022, a coalition of states, including all G7 economies, froze approximately $300 billion US in Russian state assets. Those consist of foreign currency reserves accumulated by the Russian central bank. The freezing preserves Russia's legal ownership but denies access to the funds. The rationale is that Russia owes Ukraine reparations for full-scale invasion, and immobilization keeps those assets available to enforce that obligation in the future. So the question is, does international law allow a confiscation or transfer of Russian central bank assets to Ukraine's benefit, or does state immunity oppose such transfer? There is no uniform state practice in this regard. Domestic laws on state immunity generally provide broad protection to central bank property from attachment or seizure in foreign courts. For example, under the UK State Immunity Act, the central bank's assets enjoy significant immunity from enforcement, even if those assets are used for commercial purposes. This means that central bank assets cannot typically be seized to satisfy judgment or reward unless the central bank has expressly waived its immunity in writing. Leading international law scholars and practitioners from all G7 jurisdictions argued in favor of the lawfulness of seizing Russian central bank assets, reasoning that such measures amount to countermeasures under international law that preclude unlawfulness. Others took the view that state immunity precludes the confiscation of the vast majority of central bank assets. Recent state practice reflects a growing compromise between political will and legal restraint. States such as Ukraine, Poland, and the Baltic states have advocated for the outright seizure of Russian central bank assets. Others, including Germany, the UK, France, and Belgium, have expressed concerns that wholesale confiscation would not respect international law. Just a few weeks ago, the Belgian Prime Minister stated that frozen Russian state assets should remain in the Euroclear Securities Repository in Belgium, which currently holds the equivalent of 210 billion euros worth of Russian central bank securities and cash. He acknowledged that seizing such assets would raise legal issues because they include funds from the Russian central bank that would enjoy immunity. The focus shifted to the use of interest generated on frozen Russian state assets with the creation of initiatives such as the G7's 50 billion US loan to Ukraine to be partly financed by future revenues from the interest on frozen Russian central bank assets over the next 10 years. So the recent practice of the G7 and the EU concerning the use of interest generated by frozen Russian central bank assets confirms that immunity is not an absolute principle. Rather, it is conditional upon respect for other principles of international law. Thank you.
Thank you, Dr. Marcus. And I think that shows that we are witnessing a shift in the principle itself, and it seems that motivated or pushed by the political willness on this. Thank you so much, Dr. Marcus. To complete the picture, I would like to ask George, looking ahead, what development should we expect in the doctrine of state immunity, taking all this into consideration? And which actor, states, courts, or international bodies are driving that particular change? Okay. I would have also after that follow-up questions, but please give us your thoughts.
Thank you, Abdurrahman. It's a pleasure to be here with such a distinguished company and my fellow distinguished panelists. I would ask the question slightly differently. I would say the material issue now is what is left of the doctrine of immunity? And my answer in 2 words is relatively little. The reason for that is you heard at the beginning that immunity was absolute in the last century, in the middle of the last century. A state could not be sued or subjected to jurisdiction, the national courts of another state, irrespective of the nature of the case. It didn't matter whether it was commercial or whether it was the underlying activity was commercial or sovereign in nature. That all changed when the United States adopted the restrictive theory of immunity in 1952. Now, what authority did the United States have to do that? Really none. After all, immunity is a principle of customary international law, and customary international law does not change when one country decides that it wants to change it. Nevertheless, that's what happened. It was followed 20 years later by the Foreign Sovereign Immunities Act in the United States, which itself was followed 2 years later in the United Kingdom by the State Immunity Act. And that began the prevalence of the restrictive theory of immunity that you've heard about. I won't go over all that ground, but basically you can divide the types of activities of states into two general categories, commercial and sovereign. When the restrictive theory of immunity was adopted, basically one category of immunity was wiped out. So what was left? Sovereign activity. Now, since that time, over the last 30, 40, 50 years, but especially in the last 30 years, that immunity in that second category has also been eroded. It's been eroded in two ways. Number one, and you heard about this before, some states have adopted legislation further restricting immunity even in certain types of sovereign activity cases. And I refer specifically to the United States and court decisions in the United Kingdom. But to me, the most significant change has been over the last 30 years with what my colleague Marcus was discussing, investment treaties. Now, investment treaties have effected a sea change in the law of immunity, but not by adoption, unilateral adoption of one state or even several states, reducing the immunity of other states in their national courts. This was by voluntary relinquishment of sovereignty on the part of the states themselves through this network of about 2,500 investment treaties that exist today. Now, investment treaties are specifically designed to address sovereign activity of states, not commercial activity. Commercial activity was already taken care of by the adoption of the restrictive theory of immunity. What happened in investment treaties is that states relinquished part of their sovereignty. I'm referring to classical sovereign activities such as expropriation, normal regulation of the conduct of business within their borders, and taxation, all of which are considered uniquely sovereign activity. In where one of those investment treaties applies, and now, as I said, since there are 2,500 of them, it's hard to imagine situations where no investment treaty applies. That leads to, that's a relinquishment of the second half of activity that I referred to, the sovereign activity. So when I say what is left of immunity, I would say very little. And this is a very dangerous development, especially in the investment treaties over the last 30 years. Because what you see now is a proliferation of what I call mega awards under these investment treaties, awards of multi-billion dollars. The classic example is the Yukos award against Russia, which I believe is a threat to international peace and security. I don't think that's an exaggeration. If you think about it for a second, that award has now, Marcus told us, reached about $63 billion. The claim was over $100 billion. The award ended up being $50 billion, but now with interest, it's around $63 billion. That saga has not ended. And the question you have to ask is, what do you think Russia is going to do when the claimants go around the world attaching assets to enforce that award? That brings me to my final point, which is now that immunity has almost been stripped away in so many cases, so many large cases, the real question becomes now for states, what is the key question going forward on enforcement? And here the question is not so much what assets are immune, but whose assets are they? And I think this is the burning question now in international law. As you know, states operate abroad mainly through national companies, national airlines, sovereign wealth funds, national oil companies, national mining companies. These companies all have assets abroad, and the question is, are they the assets of the company themselves, or are they assets of the state? Which is a question of recognition of the legal personality of those companies. Now there is the new frontier, I would say, in international law is the extent to which those assets may be attached or executed upon to satisfy judgments not against those entities, but against the state themselves, itself, or against their sister companies. So I think that is there's some disturbing new developments over the last few years on this issue, and I would say this is the issue that needs most closely to be monitored over the next few years. Thank you.
Thank you. Thank you so much. You just mentioned actually that this has been a development that probably will be changing too much related to immunity. Is that something pushing countries to have their own laws? Like what we have said, Marcus, you said China now, recently, they just have their state immunity law. Is that something that we can see in the future, basically, because nobody now is respecting the customary rules. So each country should have its own and basically declare it to everyone. If you would like to comment, George, maybe, or Marcus?
So there is obviously there is the international law framework, which is based on customary international law rules. And over the years, as George also mentioned, there have been a number of jurisdictions which have codified the international law principles also enshrined in the UN Convention of 2004 that was mentioned earlier, to make sure that there is a reliable set of rules. And what we have seen in a number of jurisdictions, including most recently China, but before that also in Russia and other states, is that these principles of international law, with some variations, have then been transposed into national law. So that there are differences, of course, in these national codes. There are even significant differences at some level between, say, the UK State Immunity Act and the US Foreign Sovereign Immunities Act. But the principle of generally of restrictive immunity that we have referred to is one that is increasingly being adopted by most jurisdictions, but there are some variations, and this is not a sort of set rules that have been implemented by all states across the world of similar nature. There are variances, but that the principle seems to be increasingly adopted, the one that is also in the UN Convention.
Thank you, Marcus. Do you have to comment on that, George?
Yes, I agree with that. I do not see a rush among states to adopt new laws of immunity. I think the problems that have been created by the erosion of the immunity principle are not really solved by states adopting their own rules, which invariably are going to differ from state to state, and further, let's say, diversify the rules of immunity. I think the basic problem that has to be faced, which is not being faced right now, is how the international community in general can address this erosion that has taken place over the last 75 years, not so much on the issue of commercial versus sovereign, but on the issue of sovereign activity, which traditionally has been protected under immunity, and now more and more is no longer protected.
Thank you, George. I think just we are out of time. Despite I do have one other question, but I might give the floor to the audience. They might have some questions to raise before we close. دكتور سعود تفضل دكتور سعود. Microphone, is that a microphone or we...
There isn't. I'll speak loud.
Thank you. Thank you.
I want to thank the organizers for this and distinguished
with great interest the background and the developments of state immunity. I'm a Saudi lawyer, and one of my areas of practice is state immunity, sovereign immunity. I have two questions. They're very related. The first one is about the amendment to the famous law of JASTA. It's currently before U.S. Congress. As we all know, JASTA was passed in 2016, and has created a huge breach, to put it mildly, in the state immunity, sovereign immunity doctrine. And now interested groups are trying to expand the role of JASTA to include aiding and abetting, and finding even more ways to seize state assets, including, I think, state assets that are managed by the central banks. So my question on that is, I'd like to hear your take, especially the American lawyers, on that, and what can foreign states do to try and stop that? Because it really is chipping away of state immunity. The United States has, in my opinion, the best law of sovereign immunity, 1976 law, and has enforced that before without any exceptions until JASTA came. The second question is, in the UK, you all know, being experts in the field, that the UK is now has a number of cases, probably a dozen cases, against states, and the English courts try and take jurisdiction over acts, sovereign acts, taking place outside the UK territory, which that, by the way, doesn't happen in the US, as you all know, or even the EU. And I would like you to comment on that, and also what are the consequences if the Supreme Court of the United Kingdom at the end of this year, when it hears this case, affirms the lower court's decisions which allowed English courts to take jurisdiction over sovereign acts taking place outside. Thank you very much.
And Jason to reply on JASTA, and then maybe Jonathan would like to hear from you and Dr. Marcus for the United Kingdom cases. Please, Joe, start.
Well, I would say that you're absolutely correct in the thrust of your question, and I think it raises a general point, which is that, and we've been talking about it, the development in the law of immunity only goes in one direction, and that is the direction of decreasing or weakening states' immunity. I don't believe in the near future, and probably not even in the distant future, you're going to see a retreat back to, let's say, a strengthening of immunity. So you can expect more, based on political circumstances, you can expect more and more erosion of the immunity issue in cases like the ones you mentioned, including in the UK, depending on, I'm not that optimistic, but depending on the outcome of that Supreme Court decision, which is very important. In the United States, the courts have been pretty good in terms of following the FSIA, but the FSIA itself goes beyond the restrictive theory of immunity in some respects. So in the United States, the thing to be concerned about is new legislation, which further erodes immunity. But you can see that's the direction that things are going, and I would not be surprised to see more legislation under political pressure.
I would echo those comments as well, and I think from viewing the vantage point of where the U.S. is heading, there was an opinion in the U.S. Circuit Court of Appeals for the Second Circuit recently that really extended aiding and abetting liability within the scope of JASTA. So I think to Jonathan's point earlier about managing risk, I think it's incumbent going forward to really, not just for sovereigns or state-owned entities, but institutions across the spectrum to really consider how U.S. extraterritorial jurisdiction can come into play. But I still think that there are areas for challenge in that concept of extraterritoriality. And I believe the U.S. Supreme Court currently, over the last really 15, 20 years, has taken to heart some of those concepts of trying to find a direct connection to the U.S. For the purposes of actually truly acquiring jurisdiction. We can see that in some companion statutes, such as the Alien Tort Statute, which is another statute that allows for torts committed in violation of U.S. law. So I think there's some themes ultimately to explore that this particular Supreme Court might be receptive to.
Thank you. Yeah, Jonathan, please, for the UK state of immunity law.
Thank you. Thank you. Just to comment very briefly, and I think obviously JASTA, the UK cases are a concern. There's an adage that hard cases make bad law. It's obviously very difficult for both legislatures and for courts, particularly lower courts, when faced with an atrocity or perceived invasions into privacy, particularly in the context of the human rights discourse, to be perceived as denying justice to individual quote-unquote victims. However, I'm a little bit more optimistic than George and the others, and I think you have to look at it in the context of reciprocity, but also in the context of global economic and political power. That is clearly shifting. It is shifting away from some of these jurisdictions. It is shifting, including to regions like ours. And I'm optimistic that both higher courts and governments will recognize the impact of these kind of decisions. This is the impact on investment into their own countries. Obviously, when states, through their sovereign wealth funds and others, are making investments, they consider these risks. And there's lots of opportunities for those investments in other places. So I'm, from that perspective, there's also clearly the reciprocity risk, yes? I mean, other states also benefit from immunity and need to benefit from immunity, and as increasingly they are doing business more globally, then this becomes a risk for them, yes? That the same kind of outcomes, they will face those same kind of outcomes. So I'm a little bit more optimistic. I hope that George, although he's very rarely wrong, is wrong, that it's all one way, and that we do see a little bit of rebalancing when higher courts or new political realities come into consideration. So, yeah, this is my observations.
Thank you, Jonathan. Do you have any comments, Dr. Marcus, on that?
I would just echo what was just said in that it tends to be the case that the Supreme Courts of countries tend to be more considerate in the political repercussions of their decisions than some lower courts may be. Of course, there are exceptions to that. We have not touched upon a recent decision by the US Supreme Court in the Devas case, for example. But what we tend to see is that Supreme Courts of countries tend to be more aware of the political repercussions. Of course, there are, in particular in Europe, a number of courts, also Supreme Courts of countries, such as also in Germany, for example, or in Sweden, that are very open to an extensive reading of international law obligations of states that then tend to pierce the veil as far as immunity is concerned. But we see in the enforcement proceedings or in the proceedings in relation to the assets held by the Russian Central Bank that there are clear boundaries which states also recognize in order not to cross too far the threshold, and to make sure that the principle which has been that of immunity with exceptions, as we discussed, applied for centuries, is being upheld.
Yeah, thank you, Marcus. I think we don't have time for other questions. So I think by this we're concluding this session, and thank you for Your Excellency's distinguished guests. We have heard a very extensive and rich exchange of perspectives on the matter of immunity, and we are going to see what we're going to see in the future. Actually, is not certain. Immunity is changing, and it can be in both directions. We might have some political push to get it back, or maybe, as George says, he's not optimistic, and we might go far. And immunity, we're not going to the square one we have before. Thank you so much for your listening, and thank you for our esteemed panelists, and thank you for bearing actually the journey all the way down to Riyadh to join us in this event. We concluded our session, and I would ask the panelists to remain seated until we receive some Dr. Abu Saud and Dr. Yeah, we concluded. Thank you so much.
شكراً جزيلاً لأصحاب السعادة المتحدثين على ما أثروه من طرح قيم في هذه الجلسة. والآن ندعو سعادة الدكتور حامد بن حسن ميرة، الرئيس التنفيذي للمركز السعودي للتحكيم التجاري، وسعادة الأستاذ محمد بن سعود الناصر، المدير العام للإدارة العامة للشؤون القانونية بوزارة الخارجية، لتكريم متحدثي ومدير الجلسة.